Welcome back to the channel and thank you for watching. I'm a barrister of England and Wales who helps you understand law. So Johnny Depp's lawyers are fighting back against this, let's face it, ridiculous notion that Juror 15 was an imposter and the whole verdict should be scrapped because there was a mix-up with Juror 15. So in a motion filed by Depp's lawyers, they are asking the court to strike out the memorandum in support of the post-trial motion, which was, of course, in respect of Juror 15. And also, in case you missed it, that supplementary memorandum in support of the post-trial motion was itself out of time. And quite frankly, I don't blame Depp's lawyers for filing this motion because this nonsense really has to stop. So there are three primary arguments within this motion, and I'm going to go through each of them very briefly so we understand what they mean. The first argument is that of timing, that being that Amber Heard's filing was untimely. It says that pursuant to the court's direction, Ms. Heard's deadline for submitting the post-trial motions fell on the 1st of July. 1 full month after the jury rendered its verdicts. It's undisputed that Ms. Heard did not file her supplementary memorandum until the afternoon of July 8th, 1 week later, and only fewer than 3 days before the plaintiff Depp's deadline for submitting his opposition to defendant's post-trial motions due on Monday 11th of July, no later than 10 a.m. True to form, defendant Amber Heard neither notified plaintiff Johnny Depp of her forthcoming supplemental memorandum nor sought leave of the court for filing it 1 full week out of time. Because Ms. Heard filed late and without leave of the court should grant the plaintiff's motion to strike. Now, just talking generally on timings, court timings and court deadlines, the default position is if it's out of time, it shouldn't be accepted. Usually, if it's out of time, you need to ask the court's permission. But even then, sometimes the court will still look at it, even if it's out of time. But speaking for England and Wales, these can be very strict indeed. Some cases more strict than others, and sometimes the court in England and Wales will make what we call an unless order, which is unless you do this by this date, your case is struck out, which means you have to comply with those deadlines because they are set pretty much in stone, unless you make an application to file something out of time, which this was. So even on the first argument, that of timing, in my view, there are relatively good arguments here to get this memorandum struck out because itself was out of time. But even if that argument doesn't succeed by itself, there are these other two arguments, and the court will look at all three, both individually and on balance together. Argument number 2, Ms. Heard had access to the purported new facts months ago. Purported obviously meaning what they say it is rather than what it actually might be. So they purport, they say these are new facts, but they knew of these that they say are new facts months ago. In her supplementary memorandum, Ms. Heard does not, because she cannot, make any proffer as to why she could not have discovered the so-called new facts until now. This is because the clerk's office provided the pre-panel jury list to the parties back on April 6th, more than 2 months ago, and 5 days before the jury was empaneled. Now, this echoes something that I said in my previous video, that they would have known about this jury well before the trial, and they would have had their opportunity to make any objections and should have made any objections at that point, and they didn't. In a rare moment of candor, Ms. Heard admits that she was aware of the purported discrepancy in Juror 15's birth year from the very start of the trial, because Juror 15 was clearly born later than 1945. Ms. Heard therefore concedes that she had more than enough time before the trial started and during the 6-week trial, when at least 2 alternatives were available, to investigate and discover the alleged new facts. Now, just pausing on that moment there were alternatives. Now remember, jury alternatives are members who sit and hear all of the evidence from the very start, so that if anything happens with one of the other actual jury members, such as this issue here, where they allege that there's something wrong with this juror, and this is why they're trying to get the verdict thrown out, in that case, if there's something wrong with that juror, they could have said so at any point during the trial and said, we want that juror removed, and they would be replaced by one of the stand-ins. The stand-ins or alternatives, 2 of whom were available, could have stood in for Juror 15, and none of this would have been an issue in the first place. Amber's team didn't say so, and so the alternatives were not brought in. This goes on. Clearly, Miss Heard waived any right to allege new facts she chose not to investigate for so long, much less to demand the extraordinary remedy of a mistrial. And so, in other words, that's polite lawyer speak for saying she knew this ages ago, she didn't complain about it at any point before or during the trial, therefore she can't now ask for such an extraordinary measure of, hey, let's throw out the entire verdict because this one juror seems to have had some issue in the paperwork. But because they could have raised that point at any point before and during the trial, and there were two alternatives available, this is a ridiculous request to throw out the verdict. So again, on this argument alone, in my view, it is a strong argument to strike out this supplementary memorandum. And now to the third argument, and this is equally strong, if not more so. Miss Heard cites no unfair prejudice. Now just pausing to explain unfair prejudice. Now there are a number of ways of explaining unfair prejudice, but the simplest would be it's just unfair. Unfair because the evidence would lead someone to believe something even though the evidence might be false or obtained improperly, or there's some discrepancy with the evidence, or in this process here, that there might be an unfairness about the whole procedure because of Juror 15. Now, Juror 15 was just a juror just like anybody else, and the age arguably should make no difference whatsoever, because jury selection should be random and the representatives for each party can object to each juror at any stage and didn't. There were two alternatives available which were not called upon, and as per all the previous comments made, there would have been no reason really to remove this juror from the panel, and even if there were, they should have been replaced by one of the alternatives. So what this argument is essentially saying is it wasn't unfair anyway. So even though there might be an issue with this juror, which isn't really accepted, at least in the way that it's argued by Amber's lawyers, even if that were the case, it still wasn't unfair, because in essence, you could have taken any random person that was entitled to sit on a jury who had been summoned and had turned up for jury service, sat on the jury panel, watched the entire trial, heard all of the evidence, deliberated, and come to the unanimous verdict along with everybody else. Essentially, this argument says that there is no unfairness regardless. Let's take a look at it. Even if Miss Heard filed her supplementary memorandum in a timely manner, which she didn't, and even if she had not waived her right to raise this alleged issue by sitting on the information for more than 2 months, which she did, the court should still grant plaintiff's motion to strike defendants Amber Heard's supplementary memorandum because Miss Heard failed to cite any unfair prejudice. Even assuming arguendo Miss Heard's latest thesis, i.e. that a son served instead of his father, there would be no prejudice, as Juror 15 was qualified to serve as a juror in Fairfax County and was vetted by the court and the parties' counsel just as all of the other jurors were. And there is a footnote which reads, defendant seems to have abandoned her prior baseless assertions made both by Miss Heard and her counsel on national television that the jurors violated their oaths by watching social media during the trial, which in turn influenced the verdicts. Disgraceful that Miss Heard made such scandalous allegations, and disappointing that no apology or recantation followed. And again, this echoes things that I've said before. I, along with practically every other lawyer that I've talked to about this trial, and I've talked to a number of lawyers about this trial, this was disappointing. To discredit a jury panel and to undermine them by saying that they've researched it on social media is a disappointing statement at the very least. And not only that, as per my previous arguments in previous videos, if they have researched this trial on social media, as indeed some of Amber's comments suggested that they should, i.e., quote, you can look it up online to see what happened in that UK trial, then if they were going to research it on social media, they would have found that UK trial, and that was, at the time, in Amber's favour. So the argument that they researched it on social media going against the jury was weak at best and disappointing. But nonetheless, she's abandoned that argument, as this footnote quite rightly highlights, and brings it back to the point that this juror was vetted by the court, was permitted to sit on the jury, was qualified to serve as a juror, and thus there was no unfair prejudice. In other words, it wasn't unfair anyway. Even if this is the case that they allege that this was the son instead of the father that served on the jury and so on and so forth, it's irrelevant because there was no unfairness, and there was no unfairness cited by Amber's lawyers within this supplementary memorandum. So in essence, if you want something thrown out, you have to really say that there's a good reason for it to be thrown out, and that is usually that there's some kind of unfairness. But obviously in this case there wasn't any unfairness to cite, therefore they didn't cite any unfairness. Therefore this is the third argument, the third reason that this supplementary memorandum should be struck out. And so the court will look at each of these three arguments both individually on their own merit and in the round, because courts will always look at all of the circumstances. The court will look at the initial filings against which this is directed, such as it being filed late, as it was, and it will look at all of these arguments together with all of the circumstances and draw a conclusion based on a reasonable assessment of each of those arguments and all of the information contained therein. So in conclusion and in summary, I am pleased that Depp's lawyers are fighting back against this, which can only really be described as nonsense. I don't like using such terms as a lawyer, but let's just say it's not credible, this supplementary memorandum. You can think of it as nonsense. And as I say, as a lawyer, it takes a lot for me to say something like that, but that's what I really think. So hopefully this motion to strike will be successful to strike out this supplementary motion in support of the post-trial motions. So leave me any thoughts and comments, anything you didn't quite follow you would like me to talk about once again, and in the comments below. And please do like the video and share it with somebody, add it to playlists, make sure you subscribe to the channel, all that sort of good YouTube stuff. And as always, I thank you for your time and I thank you for watching.